Welcome to Limits Exhausted, Texas's Personal Injury Litigation Podcast.
Welcome back to Limits Exhausted, Texas Injury Litigation Podcast with attorney Kiernan McAlpine, founder of McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. Kiernan has tried more than 40 cases to verdict and is frequently brought in by other attorneys to handle complex, high-exposure litigation involving 18-wheelers, catastrophic injuries, and wrongful death. I'm Shameika Rhymes, and today we're talking about mediation, what it is, what it isn't, and how trial lawyers can use it effectively to build leverage, evaluate cases, and drive better outcomes. Hi, Kiernan.
Hi, Shameika. Thanks for having me.
When you think about mediation, how often do cases actually settle there or shortly after?
It's a great question. I'm really excited to talk about this today because I was talking to one of my referral partners this week, and I was expressing some optimism about one of our cases that was going to go to mediation soon. And he's like, why? All I ever hear is about lawyers talking about how much they hate mediation, how mediation's a waste of time. This guy who doesn't do a lot of personal injury historically, but he's seen a lot of CLEs where lawyers might be talking about mediation and expressing their angst and frustration with the process. And I just wanted to talk about mediation just in a more general sense in terms of my firm's approach to mediation. So one of the things that I'm fond of doing is whenever I'm working with a mediator, I often ask them, what percentage of cases that you mediate do you ultimately settle at mediation or in the weeks or, month or so thereafter? And different mediators will give different answers. But when I mediate with mediators that specialize in like high value cases or bigger cases, the number that I've heard most often is 75%. So mediators that are mediating cases where there's a lot of money on the line have told me 75% of the time the mediation process is effective at getting the case settled.
Wow. I had no idea that they would have different answers for, for that, but that's interesting to know that because, so I'm glad we're talking about this today to get that, legal perspective. So given that most cases settle anyway, where does mediation fit into the overall settlement landscape?
Right. So the statistic that I hear quoted the most often by trial attorneys is that 95% of cases settle. So if 75% of cases are settling at mediation and 95% of cases are settling, period, there is some, significant number of cases that are not settling at mediation, but it still means that more often than not, it is effective. And, mediators that focus more on or that don't focus or that have like more smaller cases that they mediate may have a higher percentage of success. So the way that I see mediation functioning within the overall settlement landscape is, first of all, if you're interested in settling a case, mediation is a good opportunity to do it. Now, if it's a case where you kind of don't want to settle it because it's a really significant case and you're looking to get the maximum amount for the case, the landscape changes a little bit, but mediation is always a good opportunity to settle a case depending on what your client's risk appetite is and what their interests are. So I see mediation as kind of an integral part of the process, even if the case settles, even if the case doesn't settle. So mediation, I think we're going to talk about it today, kind of where it fits into all this.
Okay. So I was just thinking about this. So when there's no settlement in mediation, does it automatically go to trial?
No, not automatically. In fact, what is most commonly the case is that for a case to get the absolute last dollar out of a defendant or insurance company for a defendant, when that case will typically settle will be either in trial after the case has already gone to verdict and the plaintiff's gotten a judgment, or in like the week before trial, like right up to the point where the case is in trial, or it's in trial, or it's right afterwards. that's typically where the biggest settlements happen. I've had 7-figure cases settled during mediation. I've had 7 and 8-figure cases settle after having been mediated 3 times unsuccessfully. So, you know, mediation, if the case doesn't settle at mediation, that doesn't mean that it's going to go to trial per se. It just is more information about where the parties are, and it tells the lawyers a lot about what the parties' positions are and what it'll ultimately take to get a case done, even if it doesn't get done at mediation.
Okay, thank you for that explanation. Well, do the biggest and highest value cases tend to settle at mediation, or do they usually resolve a little bit later?
Yeah, typically not. And I think this is why a lot of lawyers that are doing CLEs that are talking about their big fish where they got a phenomenal result are often talking about how mediation was pointless or didn't advance the ball the way that they wanted it to. Is that, the biggest case that your firm has may very well be the one that is least likely to settle for a satisfactory number in mediation, or certainly in like the first mediation. Because when we're talking about significant cases that are worth like a considerable amount of money, where there's a lot of insurance, or the defendant or defendants have significant financial stature, where there's a lot of injuries and a lot of money is needed to settle the case, it just takes longer to get a case done the more money that it takes to get the case done. So, I talk to clients all the time where they're eager to settle. And what I tell them is, if you really wanted to, we could probably get this case done this week. But to get the amount of money that would be fair is going to take longer than that. And to get the maximum is going to take even longer. So the biggest of the big cases are the ones that may not settle at mediation, but mediation is still a valuable exercise to kind of set the case up to the point where it could settle later on potentially.
Well, if that's the case, then what's the real value of mediation in those larger cases?
Well, I mean, one of the most important things about mediation is that, like, I'm an addict for information in my cases. I want to know as much about my cases as I can possibly find out. And in a bigger case, it's very likely that when you show up at the first mediation, the defendant hasn't even offered $1 to settle the case. You will show up and there will be, you know, less transparency than a brick wall about how they have the case evaluated and what they're willing to offer. So at a minimum, what you're going to learn is you're going to learn how they have the case evaluated, what kind of authority they brought, and you're going to have some idea of what they feel like they might be able to stretch to get it done in the short term. So you're going to learn where the case is from the other side's perspective, which is something that we typically don't have any access to outside of a mediation. So at least we're going to discover where the other side puts the case. And sometimes cases will be valued way less than what we're expecting and way more than what we're expecting. So it's a chance for us to kind of find out what they're not telling us and what we can't find out otherwise. So at a minimum, we're going to learn where they're at. And if it's a case where they've significantly undervalued it based on how we're looking at it, it's a reason to kind of go back to the drawing board and see if there's anything that we could have missed, or just try to find out where they could possibly be coming from. Are they just delaying? Are they looking at evidence that we're not looking at as closely? Like, are things important to them that didn't seem important to us? It's kind of a mystery that we get to unravel when we find out kind of what money they're really willing to put on it.
That sounds like that's a definite reason why it's valuable to go to mediation. Now, you mentioned a few things, but from your perspective, what kind of information do you gain at mediation that you really can't get elsewhere?
Well, number one, we find out where they're starting. So where a party starts in a mediation kind of presages where they're going to end up in a certain way. Like, they're typically not going to increase what they're offering like 100 times over during the course of a day's mediation. So, when we hear their first offer, we find out a lot about sort of what their attitude is. They send us a signal with what they put on the table is their first move. We find out kind of what is the most authority that they brought? Is the authority that they brought close to getting the case done? Is it not even close to getting the case done? It's vital information because potentially it sets the case up later on. Like, even if the parties don't get anywhere close to settling at mediation, we still kind of have more information than we did at the end than we had when we started, because we started out at a certain point, we've come down, they started out at a certain point, they came up. Even if there's a lot of daylight between where things wind up, we still have kind of narrowed it down, and we've started to send the other side a signal, and we started to receive signals from the other side about kind of where things need to end up in order for us to be able to get this done, which can ultimately set the stage for negotiations later on in the case, where we can ultimately get it done potentially, right before trial, during trial, if we need to. So we find out a lot. Sometimes they'll, be very analytical in their approach to negotiation, where they'll say, this is what we're offering for these reasons, and the reasons that they emphasize will tell us about, how they're planning on trying the case, and that can be valuable information as well.
Well, how does mediation affect your ability to push a case toward trial or hold on to a trial setting?
Yeah, so this is the reason why I believe that mediation is never a waste of time. Because if you need to hold on to a trial setting and you're planning on opposing continuances, you're pushing for trial, you want to get the case in front of a jury, mediating the case, even if it's totally unsuccessful and goes nowhere, is going to be important to the judge. Because if I'm a trial judge and I'm deciding, there's multiple cases that are trying to go within this particular time frame, which case do I want to put in trial? I'm probably not, if I'm a judge, going to give somebody a whole week of courtroom time if they haven't been to mediation. If the other side is saying, look, judge, we need a continuance, we haven't mediated the case, if I'm the judge, I'm probably like, all right, give it the old college try before I give you a whole week of my time. Like, it's one of those things where it can be very useful to hold on to a trial setting. And some judges will even require it. Like, not every judge is going to require a mediation. Some judges trust lawyers to, know whether or not it's going to be productive or not. But sometimes judges will order it. Sometimes judges will not hold on to trial settings if the parties haven't mediated. And I understand where judges are coming from on that. It's like, give it a shot. If it doesn't work, okay, then you need me, then we can try the case. So I never think it's a waste of time, simply because at a minimum, it removes lack of mediation as a reason to continue a case that needs to go to trial.
Well, what should clients understand going into mediation so that they don't misinterpret how the process works? Because I think a lot of times we tend to think, oh, mediation, this is how it's going to go. And that's not at all how it's going to go.
Yeah, I have a lot to say about this one. So I think the one thing I'd like to say is that the parties that do the worst in mediation, that wind up being the most dissatisfied with the process, are the parties that really want to settle, really want to be done, really
Mhm.
want it over, but want a result that is like significantly in their favor. In other words, they want to show up, have the other side pay their asking price, and be done.
Mhm.
Right? So those are the people that I think end up the most frustrated and dissatisfied with the process. So they have to understand, like, everybody kind of has to understand that some amount of compromise is necessary to get a case done. The plaintiff's ceiling at trial, like the most money that a jury could award based on legally sufficient evidence, that's not going to be what they're going to pay you to settle a case. Similarly, we're never going to accept our worst day in court. So there's some amount of compromise that has to happen. And the next thing that I would say is that oftentimes the first 2/3 of the mediation will feel like a waste of time to the client, if not outright insulting, right? So what I tell clients oftentimes is, you may have negotiated before. If you're buying a chair on Facebook Marketplace, somebody's trying to sell a chair for $300. You might offer them $250 to buy the chair to see if you can get them to give you a better deal. What happens in a personal injury case is, like, the parties start way further apart than that. Like, if you're
Mhm.
trying to sell a chair for $300 on Facebook Marketplace and somebody offers you $10, you're going to be angry and you're not going to continue to talk to that person. But that might very well be what happens in one of these personal injury mediations, where we start with a number that makes the other side unhappy, and they start with a number that makes our client unhappy, and it can take us 2/3 of the allocated time in a mediation or more to even get the mediation to really start going, where they're actually getting a little bit more real and realistic about what they're willing to offer. So some amount of patience and not taking things personally and not reacting emotionally is very important in order to kind of stick with the process to get to the point where you can make an informed decision about whether or not to settle the case or whether to continue with the lawsuit, because it really doesn't matter where they start, it matters where they end up. So
Mm-hmm.
some amount of not getting angry and agitated at kind of what might seem like disrespect if you weren't familiar with the process is vital, I think.
And I think the example you gave with Facebook Marketplace, that really drives it home, because I have no idea what happens in mediation, but now I can visually picture this, and so if I ever have to go into mediation, I definitely feel more comfortable now that you've explained how it works. So thank you for that.
Right. Yeah. At least that's how it works in personal injury cases. The parties start way far apart. It's not where they're coming in just under to try to get a deal. It's like there's oceans between you to begin, and that's normal.
Thank you, Kiernan, for breaking this down for us today.
Thanks for having me.
That's it for today's episode of Limits Exhausted, Texas Injury Litigation Podcast. To learn more about attorney Kiernan McAlpine and his work at McAlpine Law Firm, visit McAlpineLaw.com. Thanks for listening, and don't forget to like, subscribe, and share the show so more attorneys can access these discussions on complex injury litigation.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.